Welcome to Case Law Minutes by litigationhelp.com, your public legal education provider. My name is Huizinga, and in this video we are going over the case of M&F 2015 ONCA 277, which is a Court of Appeal case from 2015. But first we need the disclaimer. This presentation is for general legal information only. For advice specific to your case, please consult a lawyer. The facts of the M&F case are as follows. One child of the marriage. Child was age 6 at the time. The child lived primarily with the mother. The father, while he had extensive time with the child, there were no overnights. The parties agreed on a private Section 30 of the Children's Law Reform Act assessment. The assessment recommended overnights to start with the father. The mother opposed the overnight recommendations and hired a critique of the Section 30 assessment. The trial judge gave little weight to the critique of the assessment. The mother appealed the decision to the Court of Appeal for Ontario. The Court of Appeal upheld the trial judge's decision and indicated critique reports of Section 30 assessments aren't admissible and are unhelpful. With respect to the critique reports of the Section 30 assessments, the court found at paragraph 30, several trial judges have admitted critique evidence and then discounted its weight. However, other courts have determined that it is not admissible because it does not meet the criteria set out in R.V. Mohan. In Mayfield and Mayfield, Justice Wine ruled that evidence critiquing an assessment report was not admissible. After considering the threshold of helpfulness often applied in family law cases, she said, prior to the decision in Mohan, the general standard of admissibility of expert evidence was the relatively low threshold of helpfulness. Subsequent to Mohan, the court, in effect, had been asked to function as a gatekeeper. The standard of helpfulness was explicitly rejected as being too low. She went on to find that critique evidence will rarely be admissible. She said that in most cases, it is simply not necessary or appropriate to have parties bring forward the evidence of collateral critique. It will rarely, if ever, be necessary to introduce the critique as original evidence or to call the critique as a witness. Her words were cited with approval by this court in s.30 versus s.30. This was an appeal from a custody order. The trial judge had refused to admit critique evidence. Epstein J.A. strongly supported the view set out in Mayfield and said, I find no fault with the trial judge's refusal to admit critique on the basis of 1, its frailties, and 2, the fact of its value to impeach the report of a court-appointed expert remained available to the applicant through cross-examination and ultimately argument. The court went on to further say that I support the view that critique evidence is rarely appropriate. It generally, as here, has little probative value and adds expense and risks elevating the animosity between the parties. The lesson to learn here is that if you agree to a Section 30 assessment, critique of that assessment is not warranted. You can get this case from canley.org using the link in the description below the video or the link displayed in the video. Thank you for taking the time to watch this video and tune in to other videos from the most cited list of family law cases.